We will go on the record in the matter 25 CF 44, State of Wisconsin versus Robert English. The state appears through District Attorney Kevin Schmidt in person. Mr. English appears in person with counsel Joel Feliski. He also has co-counsel Ryan Reed by video conferencing. We're set today in this matter for a preliminary hearing. Mr. Feliski, is this proceeding as such?
Thank you, Your Honor. It is not. We will be waiving the prelim today to preserve an offer made by the state. I do have a completed waiver form with me. May I approach?
May.
Right out of the gate, this case takes a serious turn. When a defendant waives their preliminary hearing, that's not a small procedural step. It's a strategic decision that can shape everything that follows. We're talking about a moment where rights are permanently surrendered, pressure is mounting, and the court is already moving forward. The big question is why and what's coming next once this case officially gets bound over.
Thank you. Mr. English, I have in front of me a waiver right to preliminary hearing document. Do you recognize this document?
Yes, I do.
Did your attorney go over this document with you?
Yes,
And he went over it thoroughly with you?
very thoroughly.
So you understand it completely?
Yes, I do.
Is that your signature on the bottom of the page?
Yes,
Do you understand that once you give up the right to this hearing, it's forever and you cannot get it back?
yes,
Has anyone made any threats or any promises to you for you to waive your right?
no,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily.
yes,
I will find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and
This is a crucial legal moment. By finding probable cause and binding the case over, the judge is essentially saying the state has enough evidence to move forward without ever testing it at a preliminary hearing. That tells us negotiations are already happening behind the scenes. So here's the question for you. If you were the defendant, would you gamble on a deal now or force the state to show its hand in court?
bind the matter over. Information, Mr. Schmidt?
I filed the information. It mirrors the counts related to Robert English in the amended criminal complaint.
Proceed with an arraignment.
Your Honor, I think it might be appropriate we could schedule for the arraignment.
I could do Monday, October 20th.
I have a revocation, but that's very early on in the morning.
I can do 1:30.
That will work, Your Honor.
All right, 1:30 on October 20th, 1:30 October 20th. We will see you then. We are adjourned.
Attorney Reed, before you get off, I have a question. We have a treatment court hearing later today where one of the defendants wants an attorney. Do you know if they're going to have one by that hearing? Or if you could look into it and let us know?
Good morning. I can definitely look into that.
Thank you.
Have they applied or have they talked to the PD? Okay.
Do you know the
That's
person? Do you know the person's name?
Which one wants the attorney?
Magnuson.
Ian Magnuson.
And if I can have one more follow-up question, Your Honor. Attorney Schmidt, is the termination hearing happening today?
Yes, at 2:00. Well, Ian's is at 2:30.
I just asked because if I were his defense attorney, I'd probably want time to prepare. That's why I wanted to check.
Yeah, that makes sense. All right. If not, then we just reschedule it, but just let us know or have Amanda let us know.
Yes, Your Honor.
All right, thank you. All right. We will go on the record in the matter 24 CM 230, State of Wisconsin versus Deborah Chapman. The state appears through Special Prosecutor Aaron Marco by video conferencing. We have Charlene Perrin, defense counsel, in person, along with Ms. Chapman. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Ms. Perrin, can you please recite the agreement for the record?
The agreement is that there is an ordinance that I'm sorry, my computer isn't up yet, that Ms. Chapman will enter a plea of guilty or no contest to, the remaining counts will be dismissed and read in. She has already completed all of the requirements in order for that agreement to be met, which is an anger management course. She's been fingerprinted. There's a fine that she needs to pay, which can come out of her bond. And I think there's some other requirements in the agreement that's posted online. I'm sorry, I haven't been able to log in yet. But the court has the agreement on the record.
And I believe it just had certain requirements that she needed to accomplish and to complete, and then they would be recommending, you'd just be recommending costs for that forfeiture. I believe that covers everything, correct, Mr. Marco?
Yeah, it's count 3, disorderly conduct, which would be amended to an ordinance violation for the same that was dependent upon completion of an anger management course, of which she did complete, and certification has been provided to my office, and it was also e-filed. It was supposed to be e-filed with the settlement agreement. I didn't see it, so I did e-file it this morning. There's a joint recommendation for forfeiture and cost of $300.50. That's what I remember the court saying that the standard was, I think, in one of the other cases. I believe she has $750 posted. We're asking that that be taken out of that amount and the remainder be returned to the poster. All of the charges dismissed and read in. She has no prior criminal history. That's why I believe that this is an appropriate resolution.
All right, thank you. It's close, Mr. Marco. It's $330.50. But that's fine. The court is comfortable if that's the agreement of $300.50. Okay, formal motion to amend the disorderly conduct charge 3.
So moved.
Granted. How does she wish to plead?
Guilty.
Court will accept your plea of guilt. I will assess $300.50 that will be taken out of your bail bond. The rest will be remitted either back to you or whoever posted it. I think that's all we need. The other 2 counts will be dismissed and read in. Anything further? Do you want any? There shouldn't be any need for any more argument, but all right. Okay, thank you. Then we are adjourned.
Thank you.
No, I think you are. All right, I have Dakota. I know Ms. Martin was going to, she's calling in or doing something. She was just on with my assistant. So let's go ahead with Dakota. We will go on the record in the matters 25 CF 117, 25 TR 650, 651, 652, 653, and 654. State of Wisconsin versus Dakota Mulroy. The state appears through District Attorney Kevin Schmidt in person. Mr. Mulroy appears by video conferencing capability with his counsel, Zachary Fisher, by video. We're set today in these matters for an arraignment and status conferences. Mr. Fisher, were you able to go over the criminal complaint or criminal information with Mr. Mulroy?
Yes, Your Honor. We have received copies of the information. We would waive any further reading. Enter not guilty pleas at this time. We would waive speedy trial and ask to set this for a status conference so that I can review discovery.
All right, not guilty pleas will be entered on his behalf. He is entitled to a jury trial, would be entitled to that speedy trial should he request one. Let's get status conferences. I still don't have Ms. Martin. December 15th at 2:30. December 15th at 2:30. That's your next status block date. We will see you then. Anything else, Mr. Fisher?
No, Your Honor. Thank you.
All right, thank you. We are adjourned. Thank you, Mr. Mulroy. Mr. Fisher, I don't know if you want to try and give Ms. Martin a call, but like I said, she was just on the phone with my assistant, but I'm not seeing her on Zoom.
And I did speak with her briefly before court. She told me that she's using a different device, and I guess she doesn't have enough room to download Zoom on that device. So I gave her the phone number to call in to try to call into the Zoom meeting.
That's totally fine. Or, I mean, if
Hopefully.
you want to try and give her a call, she can just call my assistant. My assistant can send her into the courtroom, whatever's easier.
Honestly, that might be easier. I will give her a call and let her know just to call back and see if we can do it that way.
All right, sounds good. I'm going to put the courtroom into the waiting room.
Okay, thank you, Your Honor. I honestly have no clue what's going on, Your Honor. I just spoke with her and she said she was going to call.
It's her responsibility to know how to use Zoom or to test it before, 3 minutes before court. So we will go on the record in the matter 23 CT 74 24 CM 175 25 CF 51 State of Wisconsin versus Shannon Martin. The state appears through District Attorney Kevin Schmidt in person. We have Zachary Fisher, defense counsel, by video conference with approval of the court. We do not have Shannon Martin. She was provided with the ability to appear by video conferencing, Zoom, or by telephone Zoom. She fails to appear. The court will place on the record that I know that she's aware of this. She was on the telephone with my judicial assistant, and she did state to Mr. Martin that she had a new device and perhaps was not able to download Zoom. Mr. Fisher gave her the call-in number for Zoom. The court also instructed that she could call into the judicial assistant and be sent into the courtroom for today's hearing. The responsibility is on the defendant's shoulder to know how to work technology to appear for court at all dates and times. If she fails to appear or unable to appear by video conferencing or by telephone, she must be here in person. She doesn't appear. It is not the responsibility of the court to ensure that the defendant can appear by video conferencing. It is a privilege, not a right. And this is not Zoom court, even though COVID has now made it a lot easier for people to appear for court virtually. It does not give the privilege or the right to have her appear by anything other than in person if she can't get it to work. I do have a message from my assistant right now saying she is now on the phone with her and she's going to send her into the conference room or in the courtroom. I will permit that to happen. She will be reprimanded at that time. Ms. Martin, thank you for gracing the court with your appearance here today.
Hi.
You're late, and I'm going to tell you, I was almost issuing a warrant. It is your responsibility to ensure that you are on time for your court hearings and not to test a new system, not to test a new device 3 minutes before your court hearing. You should have tested it yesterday or as soon as you got the new device. If you just got the new device and you weren't sure if it was going to work, your butt should have been in this chair in the courtroom. You are now 18 minutes, or actually almost 15 minutes late. You're 13 minutes late for your hearing today. Again, it's a privilege to appear by technology and not to be in person. Do not let that happen again. Do not be even 1 minute late to your next hearing.
This is one of those moments that perfectly captures courtroom reality. The judge isn't just frustrated, she's drawing a clear line about accountability. Virtual court is a privilege, not a safety net, and the message couldn't be stronger. Being late isn't a technical issue, it's a responsibility issue. Do you think the judge was too harsh here, or was this exactly the wake-up call the defendant needed?
You understand?
Yes.
All right, Mr. Fisher, did you go over the criminal information with Ms. Martin?
Yes, Your Honor. We would waive any further reading at this time, enter not guilty plea. We would waive speedy trial and ask to set this for a status conference on that same December 15th day I think we previously selected.
Not guilty pleas will be entered on her behalf. She is entitled to a jury trial. She would be entitled to a speedy trial should she request one. December 15th at 2:30, December 15th at 2:30 for a status conference. Again, Ms. Martin, if you can't get your technology to work, you better be here in person in court. I will not accept even 1 minute late. Again, do you understand?
Yes, I do.
All right, we will see you then. I believe we are in victims' rights compliance, correct?
Yes.
All right. Thank you. Then we are adjourned.
Thank you, Your Honor.
Today's courtroom session shows how fast things can move when procedure, preparation, and personal responsibility collide. From waived hearings to plea agreements and stern judicial warnings, the court made one thing clear: this process rewards preparation and punishes complacency. If you found this case as intense and revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.